Good afternoon, everybody. Somehow I thought there would be hundreds of people here crowding the door to get in to hear about the new law in Canada, which to me is very exciting, and who knows how many of us would have to seek political asylum in Canada soon. Yes. So that would be a particular advantage when you hear about the new law there. First of all, did anybody come here today because they saw the ad in the UT we put at great, oh thank you, 2 people, good. At great personal expense we put an ad in the UT, and I'm glad it attracted the 2 of you. This is the Hemlock Society of San Diego. We've been around for 19 years now, and we have meetings every third Sunday of every month at 1:30. Half of them are here, and the other half are at the Mission Valley Library, where we show our Right to Die Film Festival. And they're all free and they're all open to the public. And if you actually join Hemlock Society, you'll get a newsletter, either by mail or email, that tells you what our events are. And I also, have any of you been to a death cafe? Okay, they're wonderful. So I just want to announce this one coming up next Saturday morning.
They're funny.
10 a.m. at the Seaside Center for Spiritual Living, 1613 Lake Drive, Encinitas. They're wonderful. If you've never been to one, they're great. And I have this one notice here. We have nothing to do with them except to encourage you to go and talk about dying, which is what we do here. So today, we are very fortunate to have brought down from the great country to the north.
There's a death cafe at the Mission Valley Library.
Thank you, Bert.
On Wednesday.
Okay. Dr. Derek Smith is a practicing psychiatrist in Vancouver and a Right to Die activist. He's on the board of Death with Dignity Canada, which is the largest organization in Canada, and also on the board of the World Federation of Right to Die Societies, which is the international organization that unites all the organizations around the world that are working on this issue. And there are quite a few of them. Dr. Smith is a retired professor at University of British Columbia. And he told me today the most exciting thing is there's a practice of doctors in Vancouver who help people die under the law. And it's called Hemlocksec'd. .ca. Yay! So without further ado, Dr. Derek Smith.
Thanks very much. My inclination, being a kind of a hyperactive kid, is to walk around with the microphone, but I'm under strict instructions for filming purposes, and I must stay seated here today, so I'll do my best.
Is my head in the way? By the way, our meetings are videotaped thanks to Ken Watson here, and they're on our website. So if you want to see it again, or you've missed a meeting or something, you can go to our website and catch up. Derek.
Good. So what I'm going to talk to you about today is the evolution of the right to die laws that have come out of Canada, and they've mostly come out of the judiciary rather than through the elected representatives. Now, I've been educated since coming to California that you have a brand new law as well that was brought into force through your elected representatives, and that's a route that never would have worked in Canada because our legislators are kind of gutless people and kind of fold in as soon as anyone raises any kind of concerns. And I don't need to tell you that there's many organizations that are opposed to assisted dying, and they would never have let the politicians pass it. So we got this through the courts. So it's an interesting story. It's been going on for a number of years.
Not working?
Oh, it's going to work. Let's give it a minute. There. So.
Is my head in the way?
No.
Oh, I can remove it if necessary.
So this, to understand how laws get challenged in Canada, you really have to understand the Charter of Rights and Freedoms, which is a relatively recent document, but very important in terms of deciding whether laws pass muster. And there are two, this is from the Constitution Act of '82, and you can see that there's Section 7, everyone has the right to life, liberty, and the security of the person, and the right not to be deprived thereof except in accordance with principles of fundamental justice. Section 7 is frequently used to turn over laws. Section 15 has to do with inability to discriminate against people based on the usual things, age, sex, race, and so on. Those are the two most important principles that the Supreme Court looked at when decriminalizing physician-assisted dying. This is what the criminal code looked like before the Supreme Court dealt with it, and that was that anyone who is assisting a person to commit suicide commits an indictable offense, a criminal offense, and that no one can agree to a death being inflicted upon them. Now, having said that, suicide itself has been legal in Canada since around the 1970s. So suicide is legal itself.
A little closer to
But the criminal code was preventing anyone, doctors, nurses, or even relatives, from assisting others to commit a suicide or to assist them in dying at the end of their life. So this is the first case that hit the courts in Canada. This was a woman named Sue Rodriguez, who I happen to know personally. She had ALS, which is, any of you know anything about ALS, it's a terrible condition because you end up with progressive paralysis of your muscles to the point where you cannot clear your lungs, and you basically die and drown in your own juices, which is not a particularly happy way to go. And at the same time, no mental problems at all, no dementia or anything like that. So you know what's going to be happening, and you have to simply endure it. So she went before the Supreme Court of Canada, and by a surprisingly narrow margin lost the case. It was 5-4. Now this was in '93, and this was, well before Oregon had its law. There were no jurisdictions in the world that had assisted dying at that point, that would, at least in North America. So it was very surprising that the vote 5-4 was that close. So that was the first case that went to the Supreme Court. As you may know, Sue did die from physician-assisted death, but someone helped her. But at that point, it was a criminal offense to do so, but no one was ever prosecuted for assisting her to die. So the next one is the case that I was involved with as an expert witness, the Carter case. Kay Carter had a condition called spinal stenosis. It was not a sort of a terminal illness at that point. She might have lived for 5 or 10 more years, but it was excruciating painful, and she really had lost all quality of her life. So she, accompanied by her daughter and son-in-law, went to Dignitas in Switzerland and was allowed to die there. But after her death, her daughter became one of the plaintiffs representing Kay in the Carter case, and the name bears her name, which is a great tribute to her. So that was one of the plaintiffs who went forward. The second one was a Gloria Taylor, who was suffering from ALS, also known as Lou Gehrig's disease, as you probably know, and there were 2 other plaintiffs as well. So this case was brought to the courts by the BC Civil Liberties Association, who frequently triumph cases like this. It was a very long and involved process. The actual court proceedings themselves took several months. This is a picture of Madam Justice Lynn Smith, who was the judge who heard the case, and we were very fortunate to have her because she was a very thorough judge, and she wrote an exhaustive opinion. Her opinion was 395 pages, and the usual judgment in BC is maybe 30 pages. So she really dug into this and listened to more than 80 witnesses, and the witnesses were lined up on all sides on this. The people who were in favor of assisted dying and the people who were opposed to it. You can probably guess who the organizations were who were speaking for and against this, but she listened to all of them and listened to them carefully. So what happened in the end was that she determined, after doing this and in her judgment, that physician-assisted dying, and that was the term that was used at the time, PAD, PAD would not impede development of palliative care, and that was based largely on the evidence in Oregon and evidence in Europe that palliative care seemed to be thriving in jurisdictions where they had PAD. The second one was that the system could be designed to protect people from who are vulnerable, and this continues to be an issue with the disabilities community, that they are vulnerable in that, you know, when money gets tight, the greedy relatives or the state may wish to kill them. I think there's no basis to support that, but that doesn't stop them from being very vocal in opposition to these kinds of programs. The third thing was that doctors were capable of assessing whether people are competent or not, because to agree to any medical treatment, you have to be competent, and to agree to assisted dying, this might be the most important and maybe last decision of your life. You want to make really sure that people understand what it is they're agreeing to and that they have a firm and fixed decision. So she said that doctors are capable of doing that, which is good, because other people were suggesting that they had to go before Supreme Court judges to decide whether they were competent. The next thing was she considered the Rodriguez case, which was a precedent-setting case from the Supreme Court, and that did not prevent her from reconsidering what the Supreme Court had done at that point. She concluded that physician-assisted dying was permissible, and the words here are important: grievously ill and irremediable suffering. And the suffering was defined not by a panel of judges or doctors or anyone else, but by the individual person. The individual could say, I'm suffering too much and I've had enough of this, and that's enough to trigger physician-assisted dying. The prohibition against PAD offended Section 7, which I showed you already, and Section 15, and therefore was unconstitutional. And what she did was she gave the government of Canada 12 months to change the law, and she gave Gloria Taylor the right to have physician-assisted dying whenever she wanted it. So Gloria was the first person in Canada who had the legal right to physician-assisted dying. Now, as things turned out, she didn't require physician-assisted dying because she died of natural causes. But it gave her great comfort to know that she could have that assistance if she needed it. Now, of course, this was not good news to the government of Canada. There's really is some would say a healthy, I would say an unhealthy tension between the Supreme Court and the elected representatives, particularly the people who were elected at this time who were conservatives, who were very much opposed to sort of like the Republicans in the United States. You can imagine that they might not be ready to embrace this kind of a notion. So what they did was they used the resources of government to challenge this. So the first thing they took, the first challenge was to the BC Court of Appeal, where it was heard by 3 judges, and they upheld the appeal on a basis of 2-1. The Chief Justice, who I happen to know, voted against it. But the opinion was that Rodriguez, the precedent from Rodriguez would supersede what Justice Smith had decided. And so at this point, our side appealed to the Supreme Court of Canada, and they don't have to hear cases, they can pick and choose, but obviously this was a pretty profound significance, so they agreed to hear it. And our lawyer, Mr. Joe Arbe, went before the Supreme Court later that year. So what the Supreme Court decided, and this brings us up to February of 2015 now, the trial judge was entitled to revisit Rodriguez. So the Supreme Court said their previous decision didn't prevent other people because things had changed over time. And there are some lawyer words up there for those of you who like legal terms. But I think societal issues, societal attitudes had changed over time. And I mean, it's my view that the Supreme Court should reflect the views of society, and I gather there's a debate about that in the States with one of your justices who recently died, whether we should be making judgment based on what happened in the 1800s or whether we should be basing them on what's happening now. And clearly, this court decided that things had changed and we needed to relook at it. So what they did was they allowed the appeal. meaning that they upheld the judgment of Madam Justice Lynn Smith. They found that PAD offended Section 7, and they said because of that we don't have to go on the 15. Probably offends her too, but Section 7 is enough. And that properly designed and administered safeguards were available to protect the vulnerable. They also opined that the PAD should be available for a competent adult person. Competent means that you have to be able to understand the nature of the procedure, you have to be able to give informed consent, and you have to have a firm fixed decision on that. Adult probably means someone over 18. The person must have a grievous and irremediable medical condition, including an illness, disease, or disability, and that causes enduring suffering that's intolerable to the individual. So they pretty much borrowed the language of Justice Smith. The decision was unanimous, and that's unusual in Canada, but even more unusual was the fact that all 9 judges signed the judgment. That's only happened 3 times in the history of Canada. And what that emphasized to the politicians was that the judiciary was very united and firm on this matter. And that may have been important because the elected representatives can overrule the Supreme Court using the notwithstanding clause. It's never been used, but I think they wanted to bulletproof this judgment so that the politicians wouldn't start meddling with it. So what the sitting government did, the Conservatives, was really do nothing. They had a year to change the law. They really did nothing for 8 months. And over that 8 months, there was an election, and they were thrown out, and the Liberals came in. And we were very confident that the Liberals, led by Justin Trudeau, who you may have seen in various newspapers, he's a very photogenic young man. We were confident that they were going to really get down to brass tacks and give us a good law on this. So what they did was they appointed I'm going to digress a bit here because it wasn't that the politicians had not discussed these issues before. Between 1991 and 2010, there have been a number of private members' bills trying to allow physician-assisted dying. They'd been discussed in the House and the Senate. None of them had passed. There did not seem to be any political will to pass any of these pieces of legislation, and that's why almost by default we had to go to the courts rather than the elected people. So we were hoping that was going to change with the Liberal government. Meanwhile, there was another whole movement to bring physician-assisted dying into Canada, and this was from Quebec. And Quebec, as you may know, is a French-speaking province, and they have really a different set of values than the rest of Canada in all kinds of different ways. They're culturally different. You might think that they're strongly Catholic, but they're absolutely opposed to Catholicism, and they've managed to throw off the mantle, even though when it was a province of France, it was strongly Catholic. So unlike the rest of Canada, the politicians in Quebec formed a unitary committee. They were supported by lawyers and doctors, and they managed to draft legislation. And in spite of the fact that the government changed, they passed Bill 52, which legalized physician-assisted dying as of December 2015. That's well before the Supreme Court's decision came into effect. In Quebec, to be able to access physician-assisted dying, you have to be terminally ill, and the method is entirely by intravenous injection. That's quite different than the model in Oregon and the model you have in California now. And there's debate about amongst the medical doctors about which method is better, and I think there's agreement that the intravenous injection is by far the most, there's 100% success rate, and some of the other methods may not be successful. So that was the thinking that went into the legislation. So back to Ottawa and the House of Commons. So what the government did was they put together a special joint committee. There was a committee of all parties and a committee of both the House of Commons and the Senate, and they studied this issue, and they again called up all kinds of different witnesses, and I was privileged to testify before them. And when we saw their report, we were very, very heartened by it, because they recommended considerably broadening the criteria of Carter. So they renamed this MAID, Medical Assistance in Dying. and that's the term that's used in Canada now. The reason for that was that they envisaged that there may be some jurisdictions, particularly in the far north, where they wouldn't have doctors and nurse practitioners may be involved, so it's now known as MAID. It would include people with psychiatric illness, and it wasn't clear that Carter did until there was a judgment ruling. They recommended that the people 18 years and older should have immediate access, and they should look at a second bill to deal with competent minors. In other words, individuals who may not be 18 but met all the other criteria. And that made perfect sense to me, because why would we want someone who's 17 to be suffering from a terminal illness and suffering for 3 or 4 years when someone from 18 would not have to do that? So I don't like artificial ages, and to us the issue was one of, is the person competent to agree to this or not? They also recommended, and this was a big step forward, advanced directives, because just about all jurisdictions in the world, and I think in California, you have to be competent at the time you make the request. And if you are going into a dementing illness and you're at stage 4, 5, 6, or 7 of Alzheimer's, you're probably not competent to agree to anything. So the advanced directives was a way that an individual could, in the early stages of dementia, agree to have physician-assisted dying and appoint a representative agreement and an individual to carry their wishes forward at a point when they got to being incompetent. We already in Canada are able to appoint a representative to manage things like, if you don't want to do not resuscitate orders, or you don't want to be tube fed or stuff like that. There's all kinds of things that you can already do with advanced directives, but medical assistance in dying wasn't one of them. So the next one they recommended was national reporting, and I had strongly recommended they use the Oregon model, which has been producing annual reports for many years, and I think that's very reassuring for the public and the politicians and the people who are involved with it, to make sure that there's an accounting going on and that things aren't going haywire. So we needed national reporting. They wanted better palliative care, and they wanted a national strategy for dementia. So this special committee submitted the report to government, and the government chose to ignore it. And they chose to ignore it because in the meantime, the usual suspects, and mostly the Catholic Church, had mounted a very big political offensive to try to stifle this and to narrow, not broaden, but to narrow the criteria that were in Carter. And politicians are very susceptible to political pressure. That's why we prefer to be before judges, because we can't pressure judges, but politicians can be easily pressured by donations or threats about electing them or all kinds of other things. Also, Mr. Trudeau is a Catholic, and his chief advisor is a very strong Catholic, so I mean there may have been some of that going on in the background, who knows. Anyways, what they did was they proposed legislation in April, and the proposed legislation was this: 2 methods of medical assistance. One was self-administered, the other one was intravenously administered by a doctor. They changed the language from grievous and irremediable to natural death has become reasonably foreseeable. And that's become a phrase that no one is particularly comfortable with, because no one seems to know what it means. I spoke directly to the minister on this, and I said to her, well, it's reasonably foreseeable. I'm going to be dead in 50 years. And she said, yeah, that seems right. And I said, it's reasonably foreseeable that an hour after talking to her, I'm going to be back in my office, but if I'm hit by a bus, I'm not going to be. So what does this, can you give us some language? Well, they never did give us language on that, so we don't know what it means at this point in time. We think it's kind of moving more towards terminal illness than it is from the language of Carter. They also, before they would do other things, they're going to study things. Now, the politicians love studying because that means they don't have to do anything. So they said they were going to set up study groups to look at competent minors, to look at advanced directives, and to look at the issue of mental illness. And even though this bill was passed in June, they still have not set up any committees, and they will drag their feet, and I will be very surprised if there's any kind of report back from these committees within 3 or 4 years, and they'll probably kick it back until the next election happens. So There is a process to study this, but it's on a slow speed right now. So there are some cases that were before the court, before the legislation came in, because the Supreme Court had given, in the time frame between their judgment and the time when the legislation was coming in, the Supreme Court of Canada said, well, people who want to access PAD can do that now by going before a Supreme Court judge. So a number of people across Canada hired a lawyer and went before the Supreme Court judge, not the Supreme Court of Canada, but the Supreme Court of the provinces is where they were. And about 12 people, in fact, I don't think there was anyone who was refused, so 12 people went before the judges and 12 people were granted assistance in dying, including one case I was involved with, in which the only diagnosis was a psychiatric diagnosis. So we know from that case that Carter did include psychiatric patients. Now, the Attorney General of Canada and of British Columbia opposed that and appealed it to the Court of Appeal in Alberta. And the Court of Appeal, sensing that this was a kind of a life and death situation, heard the case within 5 days, which is almost unheard of. And they upheld the original judgment and spent 2 pages criticizing the role of the Attorney General of Canada for meddling in these kinds of things, which really heartened us because we thought they were meddling too. You know, an individual sick, close to death, having to use her own resources to fight the the government of Canada, that doesn't seem to be a proper use of our resources. And the decision was 3-0, so it was again, the judges are clearly on our side on this, and the politicians are waffling in the wind. So this was Bill C-14, which was passed in June. It exempts doctors, nurses, and pharmacists from criminal prosecution for assisting in suicide, but it still is in place for anybody else. So you as an individual could not assist your child, father, mother, wife to have assisted dying, because in Canada you would still be eligible to being charged. Doctors may administer the medication intravenously or write a prescription the patient may take. I'm philosophically in favor of oral medication, because we know that in Oregon that about 1/3 of people who get oral medication don't actually ever take it. And I think that gives people a great sense of comfort that they can have it there if they want to, but it doesn't kind of compel them to do it, whereas intravenous medication has to be, you have to decide is given and that's it. There's no, after that, there's no time for thinking. It's done. Oral medication, you can take the pills home and think about what you're going to do with them. The individuals have to be at least 18. They have to be grievous and irremediable, and they gave us some more language on that. Serious and incurable, again, that's sounding like terminal. Advanced state of irreversible decline. Suffering is intolerable, and this death has become reasonably foreseeable. So that's the language that was built into the bill, which considerably narrows the language of the Carter decision. So, what is the process? Well, it's pretty similar to what you have here. 2 medical practitioners, usually ideally the patient's family doctor and another doctor who is independent, have to agree to this. There have to be 2 independent witnesses, and these cannot be family members or anyone who may benefit from the death of the individual. They can't be the secretaries of the doctors or people like that, so there really has to be independent, and that's a safeguard to ensure that people are not going to be victimized. There has to be 10 days before the request and the provision of medical assistance in dying. And like in all jurisdictions, and this is particularly true in Switzerland, the person is repeatedly asked, are you certain, have you made a firm decision on this? Do you really want to go ahead with this? And that's the last question that you must ask before giving intravenous medication, that is whether the person has a fixed decision. It must be voluntary. There must be an informed consent, and the individual must be competent. It excludes minors less than 18. There are no advance directives and no psychiatric patients where that is the sole diagnosis. Now, the actual mechanism for doing this has been left, was not was not dealt with in the legislation. So what has happened is that all the provinces in Canada had to dream up their own set of regulations as to how this is actually going to work. So many people believe that this bill is not compliant with Carter and therefore unconstitutional because it denies people Section 7 rights. Now, if the government had taken this seriously, they would have. There was a mechanism where they could run the bill by the Supreme Court before it was passed to see if it was compliant, but they chose not to do that. What that means is that now it's up to citizens and citizen groups to mount another legal challenge to take it back to the Supreme Court to see if it's compliant, and that's an extremely costly and time-consuming process. Probably the earliest that could happen from the beginning to the end of the case would be 5 years. So the politicians callously decided not to send it to the Supreme Court beforehand. There was heavy lobbying from the Catholic Church and other religious groups to narrow the ruling. In fact, they wanted every person to have to go before a judge. Although we've had very good success with going before judges, it's a very cumbersome procedure. The courts are already clogged up, and to do that you have to hire a lawyer and do all kinds of things, get expert witnesses and so on and so forth. It would really have denied people access to medical assistance in dying simply through clogging the courts, but that's what they wanted to do. And it excludes people with psychiatric illness, as I said, and who knows what reasonably foreseeable means. Now, there are some problems with this as well. In Canada, we have a large number of Catholic healthcare facilities, and at one point, maybe 200 years ago, they were self-funded by the Catholic Church and run and staffed by priests and nuns and sisters and so on and so forth. But now what's happened is the Catholic hospitals are Catholic in name only, but all the funding for them comes from the public purse. So you may well guess that the Catholic facilities will refuse to participate in this, the same as they refuse to participate in abortion. And my view as a citizen is I don't like that at all, because they're using our tax money and imposing their values on the Canadian public. So my view is that they should not be allowed to opt out. Individuals, I understand, individual doctors should not be forced to participate in anything they find abhorrent. Abortion, assistance in dying. Like, in theory, I could be doing neurosurgery because I'm licensed. Does that mean I want to do it? No, it doesn't. So doctors and nurses are given choices around things, but I don't like the institutional opt-out, particularly when it's 100% public funding. There are also problems in that some small towns, there's a town called Comox near where I live, and the only institution within 50 miles is a Catholic hospital. And they're refusing to offer these services. So there's a problem with the institutions. The next one is that the medications that we want to use are sometimes not available or are very expensive, and you are experiencing some of the same problem down here. There's a fine upstanding Canadian company called Valiant. You may have heard of them. They buy up a bunch of small unused medications, and then they crank the prices up astronomically. They bought up the rights to EpiPen and increased the price from $200 to $600, likely going to result in the death of people who can't afford the $600 for the EpiPen. So they've also had the rights for secobarbital, so they've driven up the price of that as well. So there is an issue with access to effective medications, at least in Canada. Secobarbital is not available in Canada, for example. There's little infrastructure to implement physician-assisted dying. It's kind of been left to individual practitioners to see what they want to do. And in jurisdictions where there's great interest in the community, like Vancouver, we don't have a problem. We have a clinic that's run out of the offices of 2 general practitioners. As Faye said, it's called the Hemlocksec'd.ca. And they're on the website. You can look it up, and people from across Canada have access to help through their clinic. But in other communities, so there may be no one interested in doing it, and there's no clinic. So there's not even access to these kind of services across Canada. There are no national standards. There's a patchwork of provincial rules, mostly set out by the licensing authority. So in my province, it's the College of Physicians and Surgeons of BC who have set out all the rules for what we're supposed to do and design all the forms. So the forms in BC are going to be different than the ones in Alberta, different in Ontario. And that's just crazy making, and it's all because of the laziness of the federal government, who could have easily had a national program, but for a number of reasons chose not to do so. So there is some progress being made. It's been estimated that there's about 118 people have received medical aid in dying since the bill was passed. That's as of mid-September. That's only from 4 provinces. Because no one is in charge of collecting these numbers. It's kind of helter-skelter. And Ontario, BC, Alberta, and Saskatchewan, those are all 4 western provinces, are keeping track of this, but the other ones, the other 8 provinces and territories aren't. Not even Quebec, where it's been legal for longer than the rest of Canada. No one is in charge of collecting these statistics, so we're in a bit of a vacuum as to what's happening, and it's not clear what's going to happen about that problem. It's estimated that only about 1 in 10 of people who have requested physician-assisted dying are getting it, but I'm not certain that that's the case in BC. In BC, I think it's many of the people, the majority of people who ask are being granted medical assistance in dying. And this is true in Quebec. A number of people who have been refused have simply stopped eating and drinking and have starved themselves to death, which is a horrible way to die, I think, and it's really putting pressure on the politicians to do something about that. So here's some more progress. The organization that originally mounted the Carter case, the BC Civil Rights Association, is mounting another case, and they're collecting money from the public to do this, and they've got their funding all in place. They've got the same lawyer they had for Carter, who's a brilliant tactician, and he's doing it pro bono again. So we're launching ourselves back at the court, but it's going to take a considerable time to get this organized. In Ontario, the College of Physicians and Surgeons, the medical licensing body, has told doctors that they're okay to opt out. They don't have to provide these services, but they must make an effective referral. So if you're a family doctor and your patient comes to you and says, I'd like to have medical assistance in dying, the doctor says, well, I'm sorry, I'm not Catholic, I don't believe in that. What the college has said is that you must refer that patient to someone who will help them. Whereas the people who are refusing are saying, I don't want to even make that referral because doing that involves my participation in this process, which I find abhorrent. Now, without an effective referral, the patient, who at this point is near the end of their life and suffering and has been under the care of this doctor for maybe 30 years, is suddenly left hung to dry. They don't know where to go. They don't have any other contacts, or they're calling their friends and relatives. So I'm very much in favor of an effective referral, but a group of Christian doctors is challenging this in the court, and we'll probably see within the next couple of months whether they're able to insist that doctors make an effective referral or not. The next one is that the College of Physicians and Surgeons of BC and the colleges in the other provinces all have their own set of forms, so it's all different. In BC, the people who are collecting statistics are the coroner's office, and the certificate of death is going to show the cause of death, like ALS, as well as medical aid in dying. So the two are going to be reflected in there. There are all kinds of other issues involved, with insurance and things like that. But I think most of the insurance policies, if you read the fine print, you can't buy a policy and have assisted dying or suicide within the next 12 months. But the politicians are dithering away on what to do with the insurance industry, who would like to slip out of paying any benefits if there's been medical assistance in dying. But I think that one's going to turn out all right. The final thing is that a bunch of doctors in BC have gotten together because no one will tell us what reasonably foreseeable means. We've decided we're going to have our own definition, which is 2 years, and proceed on that definition and see what happens. Now, What it may mean is if the attorney generals of the province or Canada think that that's too liberal a definition, they may want to take us to court on that, but we've decided, since no one else is going to tell us what we should do, that's going to be our definition. So your death has to be reasonably foreseeable within 2 years. Now, having said that, I think doctors are no better at telling the future than fortune tellers, and I don't feel at all confident with predicting someone's going to be dead with 2 years, so I'm going to be very liberal with that. So it's still, at this point, left up to 2 doctors to make that decision, unless there's some intervention by the attorney generals in the province or the federal government. So I think that's where I'm going to finish. So just in summary, we've gone through a very convoluted judicial process starting in 1993. We could get no traction from the politicians who were susceptible to pressure. Every time that we've been in front of the courts, we've had a good success, and we are hoping to implement this at a national level if we can get the politicians' attention, and are going to try to broaden the criteria that are in the legislation again through the courts. So that's where I'm going to finish, and I'm happy to answer questions. You notice how I sat very still. I'm going to try to repeat the question, but your question and your identity are not going to be in the video. I'm the only person going to be seen. So the question was that the courts are moving. Well, the justice system moves as it wishes to. Sometimes they can move quickly. Sometimes they move extraordinarily slowly. So I think we've had a good response from the courts in terms of a timely response, particularly in that Court of Appeal case in Alberta, where it was held 5 days later, which is almost unheard of. So courts, when there is a life and death situation, like emergency rooms, will respond to it. But having to go through the 3 levels of, the Supreme Court, the Court of Appeal, and the Supreme Court of Canada, that's not going to happen in less than 5 years. So that's we have to just live with that and be prepared to raise enough money to keep everyone working through that 5-year period. Yes. Well, not exactly, but it's a good. Oh, sorry. You have to be a citizen of Canada to take advantage of this. You don't have to be a citizen, but you have to be eligible to be enrolled in Canadian health care. So that means you have to be a citizen, a landed immigrant, or some status like that. Tourism is being discouraged. In other words, people from other countries can't come to Canada specifically to take advantage of a medical assistance in dying. There is only one jurisdiction in the world that allows that, incidentally, and it's still Switzerland. So people from any country in the world can go to Switzerland and have assistance in dying. But the cost is pretty prohibitive. It's about $30,000. So I don't think they're out to make money on this. It's just that there's a very convoluted system. So there's going to be no tourism allowed of people who come to Canada for the purpose of dying with this legislation. Okay. The question is if you're a British subject. Well. Maybe 100 years ago there would have been a different answer.
No more.
We still have the same queen as the UK, but I don't think that would cut mustard. No, so a British citizen would not be necessarily eligible for Canadian health care. But you might be looked upon more favorably by immigration. Who knows? We do have huge numbers of people immigrating to Canada now from all over the world. So. But you'd have to, obviously, if you wanted to take advantage of that, you'd have to plan that several years in advance to immigrate. It's not the kind of thing you can do in the spur of the moment. The other thing I should add is that all of these services, because in Canada everything is paid for by the government, these services are likely all to be funded by government in the end. So we have a healthcare system that covers first dollar on doctors and hospitals. So even now, when I do it, my role is limited to doing capacity assessments. When I do a capacity assessment for someone, I simply build a medical services plan which pays me the way they would if I was doing any other kind of medical act. Yeah, I don't want to get into that because I know that the question is what are the injectable medications? I have not been involved with injectable medications, and I'm not certain that I'm the best source of information for that. There are a wide variety of medications available. In fact, there's a book at the very back I saw from my colleague, a Dutch psychiatrist, who goes into all the various medication routes. So I don't feel confident to answer that question appropriately for you. If you went to the website in Canada, you could probably get a better answer from people who are actually administering the medications. And I know that there's a protocol in Oregon as well that is public. I'm not certain what medications are being used in California right now.
No intravenous.
Yeah, no, but I don't even know what oral medications are being used. So that information is available. I just don't happen to have it, and I don't like talking about things that I'm not terribly comfortable with being accurate, and I want to give out wrong information on that. So I'm going to dodge that question. Yeah, at the very back. Yeah, so the question is, what about the third of people in Oregon who don't take the medication? I always appreciate questions from my personal chauffeur who picks me up and takes me back to the airport on a regular basis. Thanks, Mitz. Yeah, we don't know. I mean, one of the good things about the system in Oregon is that you're able to ask questions to people who take the medication and people who don't. What we do know from Oregon is that the majority of people who want assistance in dying do not want it because of relief of pain. They want it to maintain their dignity and control over how they die. We don't know about the third of people who don't take the medication. Some of them may die from natural causes. Some of them may just simply not take the medication. We don't know, but it's an interesting question. But that's a large number of people who are given access to assisted dying who don't take advantage of it. And it goes back to the other premise, and that is that the major reason is it's like a safety net. You have it in the cupboard. If things get really bad, you know you're going to be able to access it. And that gives people a great deal of comfort.
Some may not be able to swallow by that time.
Right, yeah, and that's the other problem with oral medication is that there are a number of different people who have a near death who are not able to swallow, and without intravenous route, they would simply have to continue suffering with no assistance. Mitch, you have another one. Oh, good.
Yes, on your slide you said there were exclusions, and you said there was no advance directive. And I wasn't clear if that was a double negative or what you meant by that, and the other item on that was also an exclusion. I was also...
Okay, well, the issue of advance directives, I'm not going to go back to the slide, but advance directives for physician-assisted dying or medical assistance in dying are not allowed. So you cannot, when you're competent, sign a document, get a lawyer, have a legal representative, and write down that, if I get to this particular state, I want to have assistance in dying. What you can do now is you can say, well, I don't want a resuscitation order, I don't want tube feeding, I don't want antibiotics. You can say all kinds of things you do and do not want, but the one thing you cannot say right now is that I want to be assisted to die if I get too bad. Now, there was a very prominent case in BC that took place before this legislation came in, and it was a woman named Julian Bennett who was a psychotherapist. She was 80. She was in early stages of Alzheimer's, and she did not want to go through dementia, so she managed to get medication on the internet. She dragged her mattress out to a very scenic point on her property on Bowen Island. She did it by herself because she didn't want her family to help her do that because they might be implicated in this. Then she got the medication, had her friends and family, took the medication, and wrote a very passionate website about how people really are going to have access to physician assistance in dying when they are demented. Otherwise, people are going to take action too early, and that's exactly what she did.
Our website is Hemlocksec'd.org. It's on our brochure. You can pick it up on your way out.
And I'm sending this slide set to Mitz and to Faye as well, so anybody who wants to look at the slide set, you can put it on your website if you wish, for that matter.
The other thing on our website is the outline of the end-of-life option law that we now have in California, which some of you may not know the particulars of that, and we've had meetings on it. But it is more restrictive than what Derek has talked about today in Canada. And for sure, it does not include lethal injection. So all medication has to be orally administered by yourself. And that's much more difficult. And it also applies only to terminally ill people who have 6 months or less to live.
Yeah, it's more restricted.
And also, it only pertains to California, so we still have 45 more states to go to change the law. So in the Canada ruling, at least it applies to everybody in Canada, even though it's not regulated as it might have been.
To put it in perspective, though, Canada is smaller than the state of California in terms of the number of people who live there. Yeah, I think, you know, the question is, what about medications? Because you've had a talk from some veterinarians. I could tell you what the principles are of these kinds of procedures. The first thing you want to give is something that relaxes someone, like a tranquilizer. You may want to, if they're taking it orally, you may want to give them something to settle their stomach down so it minimizes any risk of vomiting. Then you want to give something that reduces respiratory rate or stops it altogether. Then you give something that paralyzes the muscle. So if you use combinations of those things, you're going to effectively be able to help people die. The principles are no different in veterinarian medicine than they are for humans. I mean, that's one of the examples I frequently use is that we have no hesitation to relieve suffering in our animals, but we seem to have a major problem with relieving suffering in humans.
That was our meeting called How to Die Like a Dog.
The question is anybody trying to broaden the law in California? And the two organizations Joni raised are Compassionate Choices, and the answer there is no. They want the law exactly like it is, medical assistance in dying, self-administered for terminally ill people only. And there have been lawsuits and everything else, but they will not budge out of those. Catherine Tucker, who was here a few months ago, has several lawsuits going in different jurisdictions, broadening the criteria to permit physician aid in dying under the medical standards of the community at that point. She hasn't been successful in those suits, but that's another approach. And then finally, we refer people to Final Exit Network, which is a national nonprofit organization which works with people who are not eligible for the law or who live in states in which there is no law. And those volunteers, first we have to be a member of Final Exit Network. After that, there's no charge. And they work with people anywhere in the country who are thinking about ending their lives because of a very difficult illness. And they teach them how to do it, and they're with them when they do it. They don't provide physical assistance, and they don't provide the means, but they are available to anybody in the country who meets the medical criteria. They have a medical evaluation committee. And we've heard from people from Final Exit Network before. We have some brochures back there. And that is the only hope at this point for people who don't meet the criteria for the law, or who can't access it because they can't find doctors. Like there are 3 hospitals in Palm Springs now who will not abide by the law. So if you happen to live there, I don't think they're even Catholic hospitals. If you happen to live there, you are really up the creek. So our law is very cumbersome. and not easy to access. But as far as broadening the law legislatively, I wouldn't hold my breath.
What the difference is between the two countries. We are pretty much like brothers and sisters as far as I can see. We have a great many shared values, but on politics in particular, they're two quite different systems. In healthcare, there's no two more diabolically opposed systems in the world than Canada and the U.S. It's often been said that the main reason why we can't reform the healthcare system in Canada is because of the U.S. and the reason you can't reform the healthcare system in the U.S. is because of Canada. So there certainly are differences, and I don't think the politicians in Canada are any more liberal, but I think maybe the judiciary is a little different for one thing, and maybe a little more modern in their outlook of being sensitive to what the citizenry wants rather than being stuck in ideological arguments. But I can't take that any further except that you've all been to Canada, I presume, and I've all been to the States, and it looks pretty much like the same group of folks to me. Use of inert gases like helium or nitrogen, I believe that those might be methods that are popularized by organizations when you cannot get access to physician-assisted help. They're not a part of the legislation in Canada. I think I'm not aware that they're part of a formal approach to this anywhere in the world, but obviously they can be effective. 4 years ago, I chaired a panel of family members who have had relatives attempt to die using those kinds of methods, and there can be difficulties with them. So I think it's not as effective as some of the other methods, such as intravenous administration of medication, but in the right hands, it can be effective. Do you want to say more about that?
Yeah.
The Final Exit Network is not modeled on medical assistance in dying. It's not necessary to have a medical procedure, except to get access to these drugs. So when we started the Final Exit Network, which was preceded by the Caring Friends program at Hemlock, we were looking for non-medical ways for people to die. And out of our new tech meetings and that kind of thing came the helium method, which is quite effective. That has been changed in the last couple of years because helium, the kind of helium you get at party stores, has been diluted, so it's only 80% pure helium, which has been determined not to be lethal. So that was the technique recommended by Final Exit Network, which now recommends nitrogen, which is another inert gas, but it is, it's as far as what Derek said about people who've tried this themselves and have not succeeded, none of these methods are recommended without some expertise to be with you, somebody who knows what you're doing. And the same thing is true with inert gases, although they could work. And the reason Derek Humphrey wrote Final Exit was to help people who were looking for alternatives who couldn't have access to legal aid in dying. But even using Final Exit, you have to be very, very careful to follow the instructions to a T. So when people fail with using nitrogen, I have no idea what goes wrong, but it doesn't happen in Final Exit Network. It works. There's somebody with expertise overseeing this and rehearsing with you beforehand about what to do and what the right methods are and how to get the right tanks and all those very important details before those methods are used. So I don't think there's anything wrong with non-medical methods. It doesn't seem to be required that you have to be an MD to help someone die. And that's the basis on the Final Exit Network operates, even though we have several doctors doctors on the medical advisory board and doctors who are guides. It's still not a medical procedure. So that's the difference when you use inert gases versus something that needs a prescription from a doctor. Commercial nitrogen, commercial helium, commercial other inert gases are available. It takes a bit of mechanical doing, but if you go through Final Exit Network, they tell you where to order it, what it costs. It's more expensive than the helium that was used for balloon blowing up. And it's delivered to your door. And then you have to get, I think, a regulator for it. And you have to make your own bag. That's another story. Many of us here remember when Charlotte Hydorn used to make these bags and sell them. They were very nice bags. But the FBI got to her, and so that's the end of that. I have a play that I wrote called The FBI and the Bag Lady, which sometime will perform here. But anyway, it's very important that you go to the right source and get the right equipment and do the bag correctly so that it doesn't fail. Do it yourself, ending your own life. Even with a gun, which is the most successful way, which we don't believe in. We don't believe people should die violently. There's a 15% rate of lack of success. People blow their eyeballs out, and all sorts of things happen. So, ending your own life is a tricky business, and we try to provide access to the best information that's available to us, our books and our resources. The same thing is true with refusing food and hydration as a way to die, which many people do, which, as Derek said, is not a very pleasant way to die. It's not starvation, you die of dehydration. And it takes, depending on your situation, your condition, takes about 2 weeks from the time you've last ingested any fluid. And that's not fun. The data show that about 25% of deaths by refusal of food and hydration are not good deaths. The others are. Hospice can sometimes help with that. You need a caregiver who is on board with your ideas. And you can't really drink because that just slows down the process. So that's another method that's widely used. We have books back there about how to do that. So we try to bring you up to date on the latest methods. And we still get calls from desperate people about where do we get the drugs and what do we do and how is this going to work? And the answer is we try to bring you these meetings so that you are kept informed about what we know. We don't know any more than you know. There's websites that tell you how to get the drugs from China. First of all, it's not legal. And second of all, there's no guarantee that what you're getting is what you think you're getting, or that it will work. So we don't recommend that particular method. So that's about where we are. It's not easy to die a peaceful, self-determined death in this country. A little bit easier, it sounds like, in Canada. As Derek said, people can go to Switzerland. And there's 4 organizations there now that help foreigners, 2 of which we would recommend, Dignitas and Life Circle. But it is an expensive proposition. I'm not sure I would agree that it's $30,000, but it's at least $10,000, so somewhere in between there, plus your airfare, your hotel, and all that kind of thing. So we would hope that between Final Exit Network and other methods, the new law, for example, that people don't have to go to those lengths to die a peaceful death. Anyway, stay tuned, join Hemlock, support the movement, and as I said, I'm disappointed that there are not hundreds of people here because it's very important for us to know when legislation passes in another country, what it is and what we can aspire to here. So ours became effective, the End of Life Option Act became effective June 9th. And the Canadian law, I think, became effective June 19th. Is that right, Derek? Something like that. And they've already reported 118 deaths, and as Derek said, most of the provinces haven't even reported. We don't have a report. Our report will be issued once a year.
by the state, like in Oregon and Washington and Vermont. So we don't know how many people have successfully been able to use the end-of-life option there. So it's a big mystery. We try to help, but I'm not sure what we can do.
Jay, are any other states considering right to
Yes.
laws?
Oh, yeah. I think that's why compassionate choice is so rigid about the formulation of this law. Because if they start, I don't know what their reasoning is, but Colorado is very close to passing a law. New Mexico is close judicially, going through the courts, like Derek's talking about Canada. And possibly New York. You know, getting the law changed in California was a big deal because we are the largest state. And even though we were the 5th state, the fact that we were so large made a big difference. So other states can look at us as precedent and be encouraged to see that we passed a law here. That was a big coup to have that law passed. And I hope it's actually working. I see a hand back there.
You know, the question is there a sense that people may be pressured to have assisted dying? That was clearly the message that the opponents of the legislation and of Carter brought both to court and to the parliamentary proceedings. But I'm unaware of any actual situations in which that is evident. It's, I mean, already we know that there are people who are, you know, being taken advantage of by relatives to do all kinds of things with their resources at the end of life. But there is no evidence to support what's been called the slippery slope, because you start off offering it to one group of people, and pretty soon you're, then, you know, the state's involved with the killing of disabled people and so on to save money. There's no evidence at all from any of the European countries or Oregon to support that notion. So the disabilities, I put it this way, the leadership of the disabilities community is very concerned with that. We know that disabled Canadians do not share that. And one of the bills which failed to be passed in the House of Commons in Canada was put forward by a Conservative MP, Stephen Fletcher, who was fully disabled. He was in an accident and had a C2 section, so he basically has no use of his body, and he was very much in favor of assisted dying for individuals with disabilities for the same reason that everybody else should have access to it.
Specific age differences that you're seeing?
Right, so the question was about demographics, about the people who are taking advantage of assisted dying in Canada. And there's really no information on that at all. All we have now is the number count, and that was gathered up by members of the press, not from any government organization. So we're not likely to have any information about that for some time. Now, I can tell you anecdotally that most of the people who are seeking assisted dying are older. They tend to have terminal illnesses. Cancer and ALS are highly overrepresented in people who are seeking this. There are very few young people who are coming forward, and that's certainly the case in Oregon as well. So, but on the specifics for your question, you're going to have to wait, and hopefully we'll get a national reporting registry so that we can answer questions like that. Those are important. There was a recent case in Europe of a very young child who was given assisted dying, and that was because they were going to die within 2 or 3 weeks anyway. So the more we get numbers and cases, the more we can get our head around what this means for the general public. But for now, I think it's mostly elderly, mostly people with terminal illnesses, and obviously people who are in pain.
Darren, I'll just take